welcome to this month's edition of Stephen's Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
Hey everybody, and welcome to episode 11 of Stephen's Squibs monthly family law CLE. I can't believe we've been doing this for 11 months already. With me, of course, my cohorts, my partner, Caryn Stevens, and of course, GINA SZAPUCKI. What's up, guys?
Hey, good afternoon. What are we doing? June now. My God, it's almost summer break.
June 15th, and we have one more show, and then we're going to take a month off, and then we are going to start season 2. And if you haven't registered yet, we're making a $200 deal for current registrants for the entire year, and that's going to probably be over 15 hours of CLE. Everybody else has to pay $300, so jump on that if you want to. Spread the love, tell your friends. All of the money that we raise doing this goes to a really good cause, the Center for Child Counseling, which helps kids in trauma, and it also creates a trauma-informed community. I'm also very happy to announce that we are now an award-winning CLE. If you haven't been paying attention, Ms. Stevens was bestowed the Making a Difference Award from the Family Law section, and we also picked up a award from BSLE for the Award of Excellence in the Promotion of Board Certification due to the CLE. So at the end of the program, we'll show you some of that just to have some fun. And we also have a really cool board cert tip this week. Usually we tell you how to take the board cert test. This month, we're going to tell you how to appeal and win. So we have JACLYN SAROKA, who took the test last year. Initially, she did not pass, and she appealed that up to the BSLE and was able to overturn that and turned a failing grade into a passing grade. So sit tight. We have a lot to talk about, a lot of fun stuff. This is a fun month for us. And we are going to start off with Ms. Stevens talking about alimony.
Yes. So our first case this month is the Mercado case out of the 2nd District. And this was a case where the judge granted the wife's request for exclusive use of the house until her youngest minor child turned the age of majority. And in doing so, the judge ordered the husband to pay the HOA and the mortgage for the home, which is something we see quite often. However, what this judge did is that he failed to write that as a support obligation, and rather it was just written as though that the husband had to pay these obligations, but he wasn't actually given a credit for it. So when they went to calculate child support, there was no reduction against his net income as to these expenses he was paying for the house. So husband appealed it and said, hey, you should have deducted the HOA and the mortgage expenses from my net income before you ran child support, because it is an incident of support. And the 2nd District agreed with him. And even if the court doesn't call it alimony like it should have, or support like it should have, it is something that he's paying so as to support the wife, and it should have been classified as alimony, and thus it should have been reduced from his income. So this case was reversed and remanded for the court to fix its calculations. And that is the Mercado case.
I have the second case, and I was going to talk a few minutes about it until I realized that the opinion was superseded on May 19th, 2021. So we will save case 2, Ramadan, for next month when we get to the May cases. Case number 3, also our last alimony case. This dealt with long-term marriage, but instead of permanent alimony, the trial court only awarded durational alimony in a long-term marriage. And we all know that there is a rebuttable presumption that if alimony is to be awarded following a long-term marriage, that award should be permanent. If a court finds permanent alimony inappropriate because on the statutory factors under 61082, the recipient spouse has no ongoing need for support on a permanent basis, durational alimony may be appropriate even if it's a long-term marriage. And the courts kind of give an example of what that could be. Like, for example, if a recipient spouse would be able to reach the level of self-support by the commensurate with the standard of living during the marriage, by the time the durational alimony expires, well, that may be a real good reason to award durational alimony. But what Spegner teaches us is you need those findings of fact. In this case, the final judgment included the trial court's determination that the former wife had need, husband had an ability, and the court fixed the durational alimony based on 7 years, and ultimately increased it to 8 years in a rehearing. The court concluded durational alimony was fair and reasonable under the circumstances. That's not the threshold. That's not what a court has to say to allow durational alimony in a long-term marriage. The court made no findings in either judgment as to that at the end of the durational period, the wife would be self-sufficient, and made gave no other real reasons other than it was fair and reasonable under the circumstances. That alimony award was reversed. That takes us now all the way to case. We're going to jump to enforcement. We have too many cases to do every one this month, so we're going to jump around a little bit. We're going to go to case number 6. Caryn?
Yes. So we're going to just cover the Powell case here under the enforcement section. The Wilkinson case, which is number 5 in your materials, is very, very brief if you want to check that out. And the Squib pretty much covers the entirety of the opinion. So with regard to the Powell case, this was a post-judgment enforcement matter. This is out of the 1st District up in Tallahassee and Leon County. And these folks had a provision in their parenting plan. The father lived in Colorado, mom lived in Leon County, Florida. And the provision in the parenting plan that said all future travel for the children shall be agreed upon in writing in advance, including flight times and locations prior to any party purchasing plane tickets. And what this dad did is that he drove from Colorado to Florida to pick up his children for the summer time sharing. And mom said that the arrangements were not scheduled with her in advance. And she filed a motion for contempt against dad, saying that he didn't comply with the travel provisions contained in their parenting plan. And the court found him in contempt, and dad appealed. And what the 1st District said was, because this language was specific and only addressed flights, airline travel, that it needed to be agreed to, that dad was not in non-compliance and dad was not in contempt for, failure to comply with the order, because it was only about airline travel. And he made this decision to hop in the car and drive and pick up his kids for the summer. And that was totally fine. And this kind of goes back to the contempt and enforcement issues where the orders have to be clear and precise. And because this wasn't clear and precise and it didn't say car travel, it was very specific about plane travel. Therefore, it didn't just snowball into any kind of travel whatsoever for the children. So this was reversed, and dad was, as the 1st District said, he was clearly not in contempt of any order.
I think that's going to take us now down to case 8 in equitable distribution.
All right, so we have several cases here in equitable distribution this month. We're going to jump to number 8, which is the Tanner case. And this is a very lengthy opinion. And the former husband actually appealed 5 different issues, one of which was that the court signed a verbatim, or what he alleged to be a verbatim final judgment. The other issues that he appealed is whether the trial court abused its discretion in how the alimony was awarded to the wife, whether the court abused its discretion on whether the wife should have been named as beneficiary on a life insurance policy that the former husband was supposed to secure, and whether the trial court abused its discretion in ordering the former husband to give former wife his future football tickets and parking passes, which is kind of the interesting little part of this case.
Well, it would be interesting if it wasn't the University of Georgia.
Yes, it's a little disappointing to read as the Seminole fan that I am. I mean, I can understand why Mrs. Tanner might want those tickets if it were Florida State tickets, but nonetheless, these were UGA tickets, those Bulldogs up there in the SEC. But nonetheless, the court awarded Mrs. Tanner the future football tickets and parking passes for UGA. And of course, you would have thought that common sense that future football tickets would not be a part of equitable distribution because they hadn't even been purchased and acquired and owned yet. So there you go.
I would argue alimony.
Yeah.
That's obviously a historic need of the marriage.
Clearly.
Let's go Bulldogs.
You know how these college football fans are, but nonetheless.
Did I get the right mascot at least?
You did. Yes. I think it has a I forget, it has a weird name. But anyway, yes, those are the bulldogs. So.
And by the way, for those thinking that we're just Seminoles, we got
Oh.
some cocaines.
We try to keep equal opportunity around here, but nonetheless.
We're diverse.
So future football tickets and parking passes in the college football world is not subject to equitable distribution.
What if the team tanks? Like, I mean, it's
and
like
there's no value. I mean,
who'd want those tickets?
Trust me, as a Florida State fan, I know all about that this past year. So anyhow, so I think Eddie's going to cover number 9 in equitable.
I'm going to keep talking about the University of Georgia to take. No, we're going to go on to 9, which is Ortiz, which is a weird ED case that dealt with the distribution of a home, and the court basically awarded mom exclusive use and possession until the child turned 18, and said, well, I can't really distribute the house because there's no partition count pled. And there's a lengthy discussion here that you don't need a partition count to, let me get this right, divide and distribute marital assets. You do need a partition count, I believe, if you want to force the sale of the house on the courtroom steps, but that's something different. If you were just divvying up a property, that's done under 61075 equitable distribution, and you don't need a special count. The appellate court said, so what? He gave her mom exclusive use and possession till the child is 18, and we find that error to be harmless. So even though he was wrong, he was affirmed, but we got the opinion out of it. That's the end of Ortiz. Gina, you're up.
Takes us to our only income case of the month, number 10, Ortega v. Wood. This is out of the 1st District. This was a divorce action where the former wife appealed for a couple issues, but the issue we're focusing on is the former husband's income. And what had happened in this case is this was where husband owned an optical business, and within the business, he owned it with his mother. So they used the business for a lot of personal expenses with himself, with the children, and also the business paid for a townhouse or an apartment where dad and the children lived for free because the business paid for it. So the wife at trial tried to have the court impute all these in-kind benefits that the husband was receiving from the business, from the credit cards and him not paying rent since the business was paying the rent. The trial court refused to consider any of the business expenses that the husband was utilizing when calculating child support and alimony. So when the former wife appealed based on his income, and the appellate court said, wait a minute, the trial court erred on not imputing the husband with these in-kind reimbursements. They essentially said that because these were reoccurring and regular expenses that the husband was utilizing, that should have been his income because it lowers his monthly expenses. And they also suggested with this townhouse that even though he lived in this facility with the children where he wasn't paying expenses, it doesn't matter whether the business owned it or his mother owned it, even though it was a corporate asset. They said that because this reduced his living expenses and they could impute the value of what rent would be towards his income. So the appellate court remanded this back to the trial court to evaluate all these in-kind contributions that wife attempted to put in regardless of where it came from. And that's the Ortega v. Wood case.
Boom.
All right. We're going to hop over to injunctions now, and we have a couple of injunction cases this month. The first one we're going to go through is number 11 in your materials. It's La Cuadra versus Hoftling. And this is a 2nd District case up in Lee County. And this involved 2 neighboring business owners, 2 gentlemen that owned neighboring businesses. And there was a dispute over the easement and the access of the easement that got them to their respective properties. And Mr. La Cuadra parked his trucks and his equipment and his various business sort of items, blocking the easement, which then prevented Mr. Hofteling and his wife, who were the other business owners, from accessing their property. And there were some allegations that Mr. Lakidara had yelled and screamed at the respondents and had used profanities. And the court granted a stalking injunction down there or up there in Lee County against Mr. Lakidara, and he appealed it. And the second district said, well, we agree that the behavior is uncivil and really offensive. It's not exactly at a reasonable person standard that someone would feel in substantial emotional distress, which is what you do need in order to satisfy the entry of a stalking injunction. So this was reversed. And they said, based on that reasonable person standard, this just didn't meet that threshold. So then we're going to go to, I think, number 12 with GINA.
Yes, the Owens v. Owen case. This is another injunction case out of the first district. What had happened here is the estranged wife filed a petition for protection against the husband for domestic violence. And there was a permanent injunction that was shortly entered thereafter, and the husband or appellant appealed. So what he had appealed in this permanent injunction is on the grounds that this trial judge, when they went to the final hearing to determine whether a permanent injunction should be entered, this judge refused to consider or hear any evidence that the husband wanted to present, in addition to allowing him to cross-examine the wife, because the husband testified during his testimony that he did in fact install a camera to outside of the wife's home to, view. So based on that testimony that the husband presented, the judge said, husband, I don't want to hear anything else. You're not allowed to cross-examine the wife on her severe allegations. This permanent injunction is entered. So this completely violated the husband's due process, where, especially in domestic violence hearing, both parties are entitled to a full hearing prior to any judge entering a permanent injunction. Both parties are entitled to a reasonable opportunity to prove or disprove their case, regardless of what either party testifies to. So that's something to always remember. Just because one party suggests facts in their testimony, that opposing side always gets the opportunity to present their evidence and attempt to rebut that.
Gina, let me just jump in for a second and remind everybody that there's a lot of cases that talk about this, and it's really meant for, these judges that do cattle call DVs. If there's a real hearing, you got to have a full-blown hearing. That's not the same for civil hearings. That standard, we're not taking away rights. For example, your right to own weapons. So there are significant consequences to injunctions. And if you want a full hearing, you certainly have a lot of cases well beyond Owens to make sure you get that full hearing. Gina, you want to go down to modification?
Yes. Thank you for that, Eddie. This is the only modification case for this month as well. This is also in the first district. Here we have a case where the parties they filed for divorce. They both entered into a marital settlement agreement. It was ratified and made part of the final judgment a month after they entered into the MSA. About 6 months after the final judgment, the former husband filed a supplemental petition to modify his child support, alleging that there was a substantial material and unanticipated change in his income, and therefore his child support should be reduced. In that hearing, the former husband brought his employer to come to court to testify by saying that due to the seasonal changes, he's decreased his work hours. There's currently not enough hours, and that's why he's not making the same amount of income. So the trial court wound up granting this former husband's supplemental petition to modify child support, and the former wife appealed. And the appellate court reversed this ruling by saying that he had failed to show that his change in income was permanent for these reasons. as everyone, friendly reminder, in order to modify, a final judgment, you have to demonstrate it was a substantial change in circumstance. It wasn't contemplated at the time of the final judgment, and this change is sufficient, material, and permanent in nature. And when the appellate court reviewed all the testimony that was presented, they did concede that we acknowledge that his income, his change and decrease in income was not voluntary and it was not willful on his part. However, why they reversed is because there was no testimony that showed that his decrease in income was permanent in nature. The former husband himself and his employer both testified that this was a seasonal slowdown in the business, and due to other employee hires, his work hours had decreased. Yet there was no testimony presented that this would permanently impact the former husband's income, and therefore they could not ascertain whether this was a permanent change. So for those reasons, it was reversed and denied. And that takes us to parenting.
Oh, and we have a big case here. It's a parenting case out of the Supreme Court. So that means if you're taking the board cert exam, make sure you look at seeing the IGC, because I can almost guarantee it will be a significant part of the board cert test. I wouldn't even be surprised if they had a parenting essay question that dealt with something like this. My entire legal career, the law has been you needed concrete steps in an order that reduces someone's time sharing so they can get it back. That has always been in the cases. I've always had a problem with it because it seems to be a prospective modification, but we have built all kinds of reunification plans with steps, with concrete steps to get that time sharing schedule. And then the 5th DCA last year says, no, that's in contradiction to Chapter 61. That is a prospective modification. You can't do that. They certified a conflict. Conflict goes up to the Supreme Court. The Supreme Court agrees with the 5th DCA and says, all this time, you've been doing it wrong, folks. In fact, if you look at 6113(2)(c), there is no presumption for or against any specific time sharing schedule when creating or modifying a parenting plan of a child. So the Supreme Court says it violates that. It's also inconsistent with 6113 sub 2 sub c sub 2 sub b, which says the court shall order sole parental responsibility for a minor child to one parent with or without time sharing when the other parent, if it is in the best interest of the minor child. So because of all these prospective issues, the Supreme Court sided with the 5th and resolved the conflict. Now the 5th, we're going to come back in 2 cases and talk about one more thing, but the Supreme Court said the 5th went a little further. They said if you put these steps in it, it makes the order deficient. And the Supreme Court refused to go that far and make that holding because, that wasn't the case before it and all these judicial rules of determination. They said, we'll wait till there's an actual dispute before we decide that. And there's a dispute coming up because the 5th just decided another case we'll talk about in a minute. So the Supreme Court says the concrete steps are not necessary, but if you put them in there, we're not necessarily agreeing with the 5th right now that makes it an invalid order. What they're going to do in the future, I think they telegraph it here, and you'll see in a couple moments how the 5th kind of takes it one step further. But before we get to the 5th decision, the 5th decision in Natalie, Caryn's going to talk about the Couture case.
I mean, going back to the CN case that Eddie was talking about, I think you can really see it both sides of the coin. I always felt like it was odd that we were putting these steps in and really giving that prospective sort of change. But at the same time, it kept people out of court and it kept families from being affected with later litigation, ideally, because there was a set plan. So I don't know. I mean, now you're going to have these suspensions happen and supervisions occurring, and people having to come back to get reunification. And so it's to be seen how this all plays out, but very interesting. So the case number 17 is the Couture case, which just sounds like Paris Fashion Week, but this is the first district, a case out of Suwannee County. Very, very short opinion. But what this was is that the final judgment said one thing about the parenting plan and then said, see attached parenting plan, which then said something different than what the writing in the final judgment said. It was a minor technicality, a minor difference, but it was something that was reversed, and the first district ordered the lower court to correct the internal inconsistencies. So one said that it was in best interest that dad had majority time sharing, and then the plan gave it to mom. So there you go. Probably a Scrivener's error. There was an analysis of the 6113 facts. It seemed to lead that mom was the one that should have had the majority time sharing, but for some reason the actual words in the final judgment said dad. And that is all that Couture stands for. So now we're back to Eddie's 5th district party.
Oh yeah, the 5th DCA, trailblazers when it comes to time sharing. The Natali case, which is number 18 in your materials, came out before the CN Supreme Court case. So that's kind of interesting. And Natali said, if you put these prospective phases of graduated time sharing in, that's not cool. And the court did a reunification type plan, which at the time abided with all of these other opinions out there except the 5th and the CN. And the 5th DCA again came down and slammed and said, you're not going to do this, and if you put this in an order, we're going to say that it's inappropriate. They didn't certify a conflict because at the time nothing conflicted with this. So we have to wait until another DCA addresses this issue before we're going to get some determination from the Supreme Court. But I would suggest the 5th is now authoritative, not authoritative, but persuasive on the issue. And you can argue that these steps should not be in an order and use the logic that the CN Supreme Court teaches us about all these 6113 subsections. So that 5th DCA going crazy in a good way. That's the Natali case. Next case, we're going to skip down to procedure. And I think the next case is mine Helinski, which is a simple jurisdiction case. Parties filed a notice of voluntary dismissal, and the guardian ad litem still had some fees. And they thought just by filing the notice of voluntary dismissal, the court would lose jurisdiction, and therefore the guardian ad litem would get stiffed. And the 3rd DCA reminded us, well, the court does lose jurisdiction, except a voluntary dismissal does not divest the court of jurisdiction to conclude ancillary matters involved in the case, such as outstanding and unresolved motions for attorney's fees and costs and similar issues. So for example, if you had a good retainer agreement that said charging lien includes not just the stuff you receive, but your own stuff, and your client somehow dismisses your case, the jurisdiction is still resolved. The court has not divested itself of jurisdiction to hear those issues. So Helinski is a good case to have in your arsenal. Caryn?
Yeah, so another case here under, I think we're under procedure section, is case number 25. This is SHY versus PG. This is another case out of the 2nd district, Hillsborough County. Very interesting read. This involved the psych patient privilege. In this case, the child was seeing a psychologist, and the psychologist was subpoenaed for her deposition, and she was also subpoenaed for an emergency hearing. And this child psychologist showed up at her deposition, which was Ducis Tecum, and not only testified at her deposition about her communications and her treatment of the child, but also produced her entire file at the deposition as well, all her notes and things like that. I could go on for hours with the problems of that, but nonetheless, the psychologist then showed up to an emergency hearing by a subpoena and again testified about her treatment and communications with her patient, the minor child. I'm not sure why no one made a big deal out of that before now, but nonetheless, we fast forward to trial. same psychologist who's treating child now is subpoenaed to show up for trial. And at trial, she now for the first time, presumably through an attorney, claims the psychologist patient privilege under 90.503. And she tried to say that, oh, now I'm not talking, now I'm not testifying and all of that, because she probably called her, I guess, her insurance carrier at that point and whatnot, and talked to some people who gave her some good advice. But here's the problem. The court at the time at the trial said, all right, well, we're going to sustain that, objection to the privilege and not make her speak. But the issue was this, and the second district went through a deep analysis, which was, once she talked and she testified about those certain issues of her treatment and her counseling and whatnot of the child, it was out of the bag. So you don't get to kind of do a take backseat and put this all back in the bag and say, oh, now it's privileged. What was already spoken about, testified to, and put under oath on the record was out. And you can't claim privilege on something that you've already disclosed. The court did agree, the second, that anything that had not been disclosed via her notes or her testimony was still subject to privilege considerations. But what she had done, she had already said. And it made me think back to my days of being a guidance counselor when I used to do an example with my students. And we did a thing on bullying. And it was this idea that once it was out of your mouth, it was out of your mouth. And I did this with a tube of toothpaste and we squeezed it out. So once it was out, you couldn't put the toothpaste back in. So my kindergarten students back in the day understood that. So nonetheless, this is a interesting case read. I think we're going into relocation now, or
we are relocating.
Okay, relocation. All right, one of my favorite areas lately. So relocation. There's one case. This is the Durea versus Bono case. This is also out of the second, which apparently is where I'm living this month's presentation. This is Sarasota County. And what was interesting is mom here had filed a petition to relocate. She wanted to move to Oregon. I seem to have a lot of Oregon involved cases lately. Mom wanted to go out there, dad objected. And what happened is there was an underlying paternity case also for an establishment of time sharing, parental responsibility and all of that. And I guess in Sarasota County, they had bifurcated some part of this. And for some particular reason, the relocation was heard by a general magistrate who issued a report and granted the relocation, which no one took exceptions to, was ultimately ratified by a court order. And then there was the overarching paternity case going on over here. And the court then in the paternity matter, when it finally issued its final judgment, denied the mom's request for relocation. But the problem was you already had an order over here that had granted it. So mom appealed, and the second district said because the court had already previously granted it, you can't undo that. Also kind of like the psychologist case we just talked about. And dad argued, well, time sharing is still pending. And what this case taught us is that under 61-13-001, when you're dealing with a relocation, there does not need to be a final time sharing order before the relocation is granted or denied. That's what dad argued, and that is not what the statute stands for. So that is what Durea teaches us.
And that brings us to support number 28, Veith. It's a 5th district case. And this was a dissolution case where the parties were married for about 4 years. They had some minor children. And even though in the appeal there were many issues, we're only going to focus on the support issues today with some life insurance. So at the final hearing, the wife was awarded alimony and child support. However, what the trial court failed to do when calculating child support is they failed to add in the wife's alimony that she would be receiving. So that, of course, is error, and the trial court would have to go back and recalculate child support numbers, including the wife's alimony, which in turn could probably change the percentage of responsibility each parent has for unreimbursed medical expenses and things of that nature. The second issue that the appellate court did remand is the husband was required to maintain life insurance because he was paying alimony and child support. However, in order for a trial court to award a spouse be required to maintain a life insurance policy, that has to be supported by specific evidentiary findings, such as you have to put into evidence and show the availability of the life insurance policies, what the cost of this monthly insurance would be. Does the obligor have the ability to pay this life insurance payment that you're asking him or her to do? And what are the special circumstances that would warrant a requirement by the trial court to require a spouse, the obligor who's paying, only simply because they're paying alimony and child support. So for those two reasons, the appellate court reversed and remanded and said the trial court, you have to go back and recalculate these things and see if there was enough evidence that would warrant a life insurance policy. That is the VPP case.
Stephen Squibs presents this month's board certification tip.
Ladies and gentlemen, welcome to episode 11 with a very special guest. She passed this year's board certification exam, flying colors. Ladies and gentlemen, please welcome JACLYN SAROKA. JACLYN, how are you doing today?
I'm good. How are you guys?
We are great, and we wanted to congratulate you on such an incredible accomplishment, becoming board certified this year. Yay!
Thank
Congratulations. You. And when we started off this year, we heard that I think 4 people had passed, and now that number is up to 6. What happened?
So I sat for the 2020 board certification, which was interesting because it was mid-March, right on the precipice of when things really started to get a little crazy. So that was an interesting experience to start. And then they notified everyone of the results around mid-May of that year. Unfortunately, my initial scoring, I got the big fail letter. So I wasn't too pleased with that. And so I then exhausted the remedy of the appellate process. We can get into that, but essentially in about the end of February of 2021, so almost an entire year from the time that I initially sat for the exam, I was notified by the bar that I had in fact passed, and another individual who did, I believe, a similar procedure that I did, and exhausted the full appellate remedy as well, she also passed.
I don't know if people even realize that rejection or that letter saying you didn't pass is not necessarily the end of the road for that year's test. And there is an entire process that you can appeal it directly to the BSLE and have them reconsider it. And in this year, 2 of the cases, it made a big deal to, like you.
Yeah, certainly.
Well, we appreciate you sharing that this has happened to you, because I can imagine the roller coaster of emotions that you've been on. And I know from serving on the board cert committee, the people who write the test are not professional test writers. We're just other board certified attorneys. And every year we pop out a different test with multiple choice, essay, the ethics quiz. What did you think, and what inspired you to pursue the appellate process on your test?
Well, I guess just in context for people who don't know me, I know you know me minimally. I know Caryn very well. I certainly am not a quitter. I don't quit, and I was particularly upset and perturbed in this situation because I'd actually done what I believed I needed to do to become prepared and ready for the exam. I also thought, I've heard a lot of people say everyone walks out and thinks they failed. I didn't. I thought that I finished the exam. Of course, there were a few questions that you think back on and you think, oh, whoops, forgot about that. But for the most part, I was really, really surprised, particularly given the disparity and some of my grading. Some of the grading was perfect. Some of the grading was not perfect in terms of scoring. And so I think that I think I would have reviewed my exam, and there's a difference between appealing all the way up to the BLSD like I did and an initial review of your exam if you don't pass. And so I think that upon the initial review of my exam, had I been super far off or had I not seen some irregularities, and as you mentioned, this isn't a standardized test. The Board of Bar Examiners don't issue this test. This is a test that's created by professionals, and I don't fault them. I mean, they're not professionals. They're not professional test writers. But when I really did a close review, I certainly saw a basis to appeal, and ultimately, because of the amount of work that I'd put into it ahead of taking the exam, I couldn't just shelf it and just take it the next year. And I think some people make that mistake. I know there are some individuals that I think in hindsight who have, generally heard what happened in my story, have a lot of regret that they didn't see it through. And so for me, it was really, I knew I did what I needed to do to pass. I wasn't a sore loser, but I wanted, to see it through completely and not quit, because it was really important to me. And it was a massive investment, time, money, lack of billing on my cases in advance of the exam. And so what I didn't realize was the amount of time that would take me from that May notification all the way until, almost approximately a year later to see it through. But I'm glad I did. And I think people that are in a similar position should try.
And can you tell us exactly what you did and how many hours you did in the preparation for the exam?
Sure. So I'd been teetering with the idea of taking the exam for a couple of years. It just wasn't working through my schedule at the time. And so I committed to 2020 exam. And I would say in about October, definitely in November, I essentially outlined, I took the red books. They're there for a reason. Everyone has them in their office for a reason. And I created essentially a study outline based on the table of contents that were in the red books. I also ordered your books, your Squib books, and the Florida Law Weekly green bound book. I don't have them behind me. I normally do, but I tried to declutter my space. And essentially what I did is similar to the bar. I did it by topic area over a large period of time. So I'd say before the end of the year, November and December, I was able to allocate about an hour, 2 hours, sometimes more if there were areas I wasn't so familiar with, like surrogacy and things that I don't come across in my everyday practice. And so come January of 2020, I at least had a working outline. I'm like you, Eddie, I like to handwrite things. I do a lot of mnemonics for statutes. There's the die factors for alimony. You don't have to reinvent the wheel. There's a lot of people who have taken this exam that have their materials, and that can help you if you're one of those people that learns like that. And so come January, I was in a place where I knew the places I needed work on and the things that I definitely had pretty solid. So come board certification, where I got really sick. A lot of people, I wasn't even allowed, I couldn't even make it out of my room. It wasn't COVID, but I was knocking on the hospital door essentially. Unfortunately, I couldn't make it to the review course, but from that point forward, I probably dedicated at least 3 to 4 hours a day. And then I would say the 3 weeks in advance of the exam, I probably was spending 10 to 12 hours a day. So if I were to quantify the amount of hours, I would say at least 200, and that's being extremely conservative, probably more than 250 hours of just nothing else in the room, straight focusing.
And do you think it made you a better family lawyer?
Oh, certainly. I mean, there were things that I still, to this day, the only reason I know it is because of the extensive studying I did. And I actually kept my outlines, I kept my handwritten notes, and it's helpful. Even in trial, I'll remember a mnemonic and be able to rattle off, elements of a statute that I would have I'd have no idea. I'd have to look it up.
So what advice would you give someone like Caryn, who is thinking about taking board cert but hasn't taken the plunge? What would you tell Caryn to give her that push?
I think that, we have a lot going on in our lives. When you get to a certain level, particularly people who are exclusive family law and matrimonial lawyers, there's always a lot going on. So I think planning in advance, I knew in the summertime I was going to do it. I didn't book any trips. I had a notice of unavailability out. I really kind of mentally prepared myself in a way that, you know, I could never run a marathon, but I could imagine if somebody was planning on doing that, you get your body right, you get your mind right. And I was really just staying the course on that. And you just have to make a commitment. I mean, there's people who can lock themselves in a room and study over the weekend and wing it and somehow they pass, but you don't want to get that rejection letter. I can tell you that firsthand. That is one of the worst feelings in the world. And so if you're going to do it, you're going to spend the money, spend the time, and, you know, focus yourself. And I believe genuinely, I've only met maybe one or two people who have not been successful that truly put in the time. If you put in the time, you should be okay. And I think that's the big difference there.
So if you take it and you don't pass, at a minimum, go do the review and see how you did.
Yeah, so I don't know how many people actually know the process. I certainly didn't. Perhaps I was a little presumptuous in thinking I would never have to think about it. And I think a lot of us, whether we just don't imagine ourselves being in that spot, or we just don't want to think of ourselves being in that spot. What happens is you take the exam, you're notified via email by the bar liaison whether you passed or not. A lot of an item that people don't know about is under the rules, you are permitted to receive your actual breakdown of your, hold on one second, your actual breakdown of your score. So there's 5 essays, there are 25 short answers, 30 multiple choice. And so immediately I asked for that. And so I remembered exactly what the 5 essays were in chrono order. And I had actually, after the exam, it sounds a little bit crazy, but it's a helpful tip for people. If you take the exam, I jotted some notes about some of the essays that I thought may have been problematic or some of the things I wasn't sure about. So I had context of what they were. And I was able to quickly look and see, obviously I didn't remember the short answers or multiple choice, but you know, when there was a glaring discrepancy in your scores, if you're getting, for example, 5s, and then all of a sudden you get a 1 or a 2, you're obviously going to want to take a look at that essay, particularly if it's something that you come across in your practice and you're familiar with. It seems a little off. So that was the first step. Then you need to give notification, and there's very strict time parameters. So anyone who finds themselves with a dreadful rejection letter, go and pull the rules. They're on the certification section of the family law section website on the bar. And there's real tight time constraints, similar to an appellate process. You don't do it, you're not going to get the relief. So from that point, because of wonderful COVID, traditionally you have an opportunity to go in person 3 different times for a time period not exceeding 8 hours. There's various locations in the state. My year, because of COVID, that process was delayed. You're supposed to do that within 30 days of getting your fail letter, and it got pushed out until the month of August. So I had to wait for months and months and months to even see my exam, which is no one's fault. We were trying to be safe. And I reviewed it via Zoom. You get 3 opportunities. Our time was limited the year I took it because of the logistics of the Zoom, but I think for the folks that just sat for the exam or the people that are about to take the exam next year, it should be in person. You get it's all confidential, so I can't really speak to my particular exam, but you get a copy of your exam, the materials you had, the model answer, and the exam, and you really can laser in. Another helpful tip for people who find themselves in the spot that I was in, with that score sheet, I was able to highlight the questions that I got wrong. And I created kind of a little grid where when I went in for the review, like I said, I was more time constricted than 8 hours. I would have had plenty of time, but I just narrow focused, went to those, chalked off the ones I just blatantly got wrong, and then I focused in. And then from that point, when you do your last review, you give notice to the Florida bar if you're going to do a petition for a regrade. And so at that point, again, time is important. There's parameters there. You notify the bar and you draft a petition for a regrade. You don't have the original exam. You don't have your answers. All you have are the notes that you were able to feverishly transcribe or take down when you're doing your review session. You're allowed an attorney. I had my partner represent me at that stage. There's non-disclosures that go out to the folks that help you. And then at the BLSC level, I had Melinda Gameau as my attorney. And so that person's good because they look at it objectively for the most part. And if they do it correctly, they'll look at it objectively and tell you, I think you deserve this, or this seems completely messed up. So getting someone you trust that's smarter than you are, or that, you know, you can get an objective opinion from is good. So when you file your petition for regrade, mine was, I can't talk about substance, but I can at least tell you it was 275 pages total. It was a serious endeavor. I think you have 30 days to prepare that. And then that goes to the board certification committee. The two officers make a decision on that. It's, you know, that everyone's different. So at that level, theoretically, they could say, oh, we made a mistake, which results in a pass. However, in my circumstance, I then continued on to the BLSC, who appoints a 3-panel independent review panel. There are 3 board certified attorneys that had nothing to do with the exam. They meet with one of the heads of the BLSC and regrade the challenge portions of your exam. At that point, their recommendation is given to the BLSC and the committee. If their regrade resulted in a pass, I think that that pretty much means that you've passed at that point. If their regrade does not, your second to last remedy is you can appeal to the BLSC. And essentially there are very, very limited bases from which you can appeal. There's 2 that come to mind, which is, you know, discrimination, things of that nature. That was certainly not my situation. And then there is arbitrary and capricious grading in the overall process. And so you have that opportunity. It's they actually, you know, it's very uncommon. There's only 2 reported Florida Supreme Court cases that are like 20, 30 years old that talk about, you know, folks that have done that and how those appeals turned out not too great. So at that point, I decided to go the full distance, and you do a notice of appeal to the BLSC. I asked for an expedited or a consolidated hearing and everything kind of in one shot at the next BLSC meeting, because unfortunately, the next board certification exam was about a month away. But for knowing what was going to happen there, I would have either had to wait and defer a year, or I would have had to sit for the exam while simultaneously waiting for the results of the appeal. So that's what I did. And I appeared with Melinda Gameau at the BLSC meeting. And I believe that was in the beginning of February. And there's about 25 or 26 chairs from the different sections. You put on your case, they have an opportunity to ask questions, and then they render an opinion or a directive. And without saying precisely what happened in my situation, inevitably what happened was about 2 weeks later, my score was ultimately sufficiently high enough to receive a passing score. And so I got the formal notification and I got my board certification plaque. I mean, it was a little anticlimactic, but at that point I was just happy. And like I said, the other individual, I believe a similar situation happened. I don't know the specific details of her appeal.
So through your resiliency and hard work, it all paid off.
Yeah, I mean, it's definitely, I think that a lot of, you know, lessons learned, and I don't regret it, because I also think that I learned a lot through the appellate process. I mean, I took the appeal really seriously. Like it was it was my own life on the line in a certain way. And so through doing that process, you continue to learn. And I just, I feel really, really bad for people who didn't exhaust all of their remedies, particularly people who were close to that cutoff. And, the difference of 1 point on an essay is 5 points. I mean, that's significant. So another thing that people don't know about is on appeal, short answer is worth 2 points, but there have been instances and it's spoken to in the 2 Florida Supreme Court cases on this process that are the only that exist, where half points are given. So for the folks that are on the cusp, a couple of points, and they're just looking at their exam and they're thinking, it's all or nothing. I got part of it right, not the other part. You can get partial points. So anyone out there that's taking it or that's waiting on their results, if you get that rejection letter, don't be completely defeated, particularly if you put the time in. I mean, it's worth pursuing.
Well, JACLYN, I appreciate your tips, and more importantly, we appreciate you sharing your experience. Not too many people would be willing to share that, so we really appreciate it.
Great. All right. Well, good luck, Caryn.
Caryn, do you have any questions?
No, I was going to say, I wanted to compliment you on being sort of like a trailblazer for some of us who may find ourselves in similar positions. And I've always said that to you, that you never gave up. And I'm not surprised, but I'm super impressed and I'm happy for you. And I've already told you that privately, but I'm really proud of you.
Yes, and that's super sweet. And, to the extent that this part makes the cut in here, everyone's just been super, super supportive. I think that all of us who are board certified or have tried to become board certified understand what you put into it. And so, listen, if I had done the appeal and I had to take it again, there's no shame in that. I mean, not everyone passes the first time. Super, super smart people that you probably don't even know didn't pass the first time, maybe not even the second time. And it's kind of this dirty little secret, and it shouldn't really be stigmatized. I mean, I think just even trying is admirable. And if the first time you try and you get knocked down, try again, and you might have to do that a couple more times, but sometimes it works out.
And you are proof of that. Being on your first go and being resilient and fighting a battle that most people wouldn't even think about. So JACLYN, both Caryn and I are very proud of you. Yay.
Oh, thank you guys. And thanks for all the work that you do. It's super entertaining and for a good cause.
And thank you for sharing all of these tips with our viewers.
Thank you for joining us for this month's edition of Stephen Squibs' Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.
The Alberto Romero Making a Difference Award. This year, this is an award that is given for making a difference, and it's not only given to people that do things for the family law section, but do things on other basis. Caryn Stevens. Caryn is a partner at Ward Damon. She's been practicing law for 9 years, but before that, she was a mental health counselor, the director of the Guardian Ad Litem program in Broward County, and an elementary school guidance counselor. She's vice president of the Susan Greenberg Family Law Inns of Court of Palm Beach. Caryn has contributed to the creation of over 12 pro bono CLE courses for the Center for Child Counseling. She's contributed articles to The Commentator and continues to do countless hours of pro bono work whenever asked by anyone. She's on the board of directors of the Women's Foundation of the Greater Palm Beach, and she's a graduate of the Leadership Palm Beach County. She also co-chaired the Arts for Media Day for Youth Leadership Program in Palm Beach. Thank you for all you do, not only to the family law section, but for your community, because without that, again, things would not get accomplished. Thank you.
I want to thank Doug Greenbaum and the Family Law Section for the Making a Difference Award this year. I really appreciate all of the confidence and the support and the honor bestowed upon me by our members of the Family Law Section. I also want to thank our team over here at Ward Damon. Without all of their support, I would not be in this position to give so much service and help to the community around the state and here in Palm Beach County. I want to thank my law partner, Eddie Stevens, for his ongoing support, his cheerleader behind the scenes, and for essentially being the torch carrier of public service here at the office and encouraging us to always do good and really make a difference. I want to thank our paralegals, Emily Golish, Angela Cahill, and Catherine McCarthy for always making me look fabulous and controlling my calendar so that I have time to do all of these wonderful things and give back to the community. I want to thank our other attorney, GINA, SZAPUCKI, for her support and also always making me look good and being a cheerleader in all of the good things that we do. I want to thank my parents, who always encouraged from a very young age to always give back to the community. I was the girl who graduated high school with millions of service hours, who went through law school giving pro bono hours, and I'm glad that I can continue to do that in my practice now as an attorney. This is my 10th year as a member of the Florida Bar. It's my 10th year as a member of the Family Law Section, and I'm honored to be a part of this amazing group. I also want to thank my husband, who spends countless hours dealing with my crazy hours and always making sure that things are taken care of and being the best partner and supporter that I could have to let me do all these wonderful things. And I thank you all for this award. I thank you for considering me amongst all of our section members of doing these good things, and I promise that I will continue to always make a difference in our field and our practice area in the state of Florida and make sure that our children and families are getting the best service, assistance, and help that we could provide. So thank you again. Thank you, Doug, for this award, and thank you for recognizing me. I appreciate it.
Now, I have the privilege of introducing this evening the winners of the Excellence in Promotion of Board Certification Award for 2020 and 2021. The Florida Bar Board of Legal Specialization in Education has established an annual award for excellence in the promotion of board certification. The award recognizes excellence and creativity by the Florida Bar Board Certified Lawyer in advancing the public's knowledge of and reputation for legal board certification. And the 2021 recipient is Mr. Eddie Stevens. Eddie is a marital and family law board certified lawyer and equity partner in Ward Damon, where he leads the family law department and manages community relations for the firm. Mr. Stevens has created a monthly family law CLE, and every month he features a board certification tip of the month, promoting board certification. The CLE generates approximately $100,000 per year in revenue that is donated to a nonprofit organization, the Center for Child Counseling. Mr. Stevens has also created a special 90-minute program, Tips on How to Pass the Family and Marital Law Board Certification Examination. He has been actively involved in the Palm Beach County Bar, the Florida Bar, and the Family Law Section of the Florida Bar for the past 23 years. Mr. Stevens has also presented at the Marital and Family Law Certification Review Course and has formerly served as chair of the Board Certification Committee for Family Law.
And thank you, BSLE, for this really special honor. I do believe if you do something in life, you know, it's important to be the best at it. And I think board certification is an indication that tells you who's the best. So everybody getting pinned today, congratulations. It was an incredible achievement. I agree with Steve Lesser. This is something every attorney should be striving for. I've been licensed now 25 years and board certified 20. I got certified as soon as I possibly could. And I also think, in addition to striving for that, as an attorney, we kind of have a duty to serve the profession. And I think we have our duty to serve the community. So we came up with this little project that kind of did everything. It promoted board cert. It served the profession by doing 12 monthly CLEs. And all of the money that we raised went to a great charity, the Center for Child Counseling. Now, 100 grand was our goal at the beginning. We didn't quite hit it, but we're poised to surpass it next year because we're going to do it again. And 12 CLEs is a lot of work, but it's it's also a whole lot of fun. And I have a couple people, it wasn't just me. I had people that helped me put this all together. Specifically, my law partner, Caryn Stevens and GINA SZAPUCKI. Every month we do the CLE and we invite someone in to give a board cert tip. In the Center for Child Counseling, I need to thank Dominica. I can't believe I'm nervous. This shows you how important this is. Miss Nolan, who does all the behind the scenes work of getting our CLE up and running and registered. The CEO of the Center for Child Counseling is Renee Lehman, and she gave me free reign to create this curriculum and raise money, and I really appreciate that kind of freedom. And I also want to thank everybody at the family law section. Before I did this, for 10 years with a fellow named Ralph R.T. White, we did an annual case law update, and by participating in the section and having these speaking opportunities, it gave me the courage, the discipline, and the skill set to be able to do this type of a project. So to all the past chairs and the current chair, thank you. I also finally want to just thank my wife for being my muse and inspiration. Jackie, I love you, and thank you for putting up with me and all the time I spend doing all this fun stuff. Hopefully this inspires people to, do whatever it is you're good at and figure out a way to, serve all these different things, find a way to serve your profession, find a way to serve the community, because, it's important. And as board certified attorneys, you guys are now looked upon as those leaders. So thank you very much for this incredible award, and to all the new board certified folks, congratulations.